Thank you. In December 2010, following a trial in the Supreme Court of New South Wales, Keli Lane was found guilty of the murder of her baby daughter Tegan. Ms Lane's non-parole period expired in May last year and she's currently eligible for parole consideration. There are statutory criteria for the grant of parole, and relevantly these are found in sections 134 to 135A of the Crimes Administration of Sentences Act. And they set out the factors which the State Parole Authority must consider when considering whether or not to make a parole order. These factors focus on the safety of the community, and they do not include the views of this House. They also do not, sadly, include the experience of the person in prison, and I listened with great concern to what Sue Higginson informed us of the situation that Keli Lane has faced in jail. That is appalling, and it should be dealt with, and it should be dealt with by the prison authorities, and it should be dealt with in the proper manner, and it is in fact, appalling isn't even the word for the fact that it was able to continue for as long as it did. It is just wrong on every level. But sadly, that is not a relevant factor for parole. Ms Lane, because of the nature of a crime, is also subject to section 135A, that a parole order must not be made unless the authority is satisfied that the offender has satisfactorily cooperated with the police to identify the victim's location, in this case, the grave and the remains of baby Tegan. As a serious offender, her parole was considered last March. As we've heard, it was refused. And in its determination, the Parole Authority, and I think importantly, with the benefit of submissions from Ms Lane's legal counsel, considered the effect of section 135A. It was agreed by all parties that baby Tegan's body has still not been located. It was recognised that the police report required by 135A provided that, quote, the offender has not cooperated with or assisted police with searching for or locating the deceased. The State Parole Authority held that as a matter of statutory construction, 135A creates a separate and distinct regime which must be followed for offenders such as Ms Lane, and that the provisions of this section had not been met. It is open to Ms Lane to appeal. I'm not aware that there has been any appeal in relation to that finding by the State Parole Authority. Keli Lane maintains her innocence and that there is no body to find, but both the jury at her trial and the Court of Criminal Appeal rejected these claims. We can all feel sympathy for Ms Lane, but at the end of the day, if this motion asks us as a legislative body to interfere with the statutory decision-making of an arm of the executive, the State Parole Authority, it is improper and we should resist the invitation to do so.
Further speakers. Ms Kate Fairman.
Thank you, Madam Deputy